हेलो एवरीवन, वेलकम टू लीगल कैफ़े। आज हम बात करने वाले हैं एक रीसेंट लैंडमार्क केस लॉ की। कॉन्स्टिट्यूशनल लॉ का केस है। अगर आप किसी भी ऐसे एग्ज़ाम की तैयारी कर रहे हैं जिसमें रीसेंट केस लॉज आते हैं, फॉर एग्जांपल क्लैट और नेट और एनी ऑफ द जुडिशरी एग्ज़ाम्स और द APO एग्ज़ाम्स, स्पेशली इन केस ऑफ हरियाणा और Delhi, then you should definitely watch this video, because we all know that recent case laws are important, but which ones? So this one, we are sorting it out for you. You don't have to go down that rabbit hole. So let's begin. So the case law name is Sukanya. You have to write this down because this case name can also be asked, okay? Sukanya Shanta versus Union of India. So this is 3rd October 2024 judgment of the Honorable Supreme Court of India. 3 judge bench gave this judgment. So constitutional law का केस था. Basically Supreme Court ने ये held किया है, जो caste based discrimination हो रहा है in the prisons should not be continued because it is against the constitutional principles of our Constitution of India, of course. So let's learn what the facts of this case was. So the facts start from 2020. So there is a platform you must have heard about, The Wire, wherein there was a journalist by the name of Sukanya Shanta. She wrote a report wherein she highlighted that the administration of the prisons, the allotment of the labor work and the basic management of such prisons is being done according to the caste system. She attested a lot of testimonials and highlighted a lot of provisions to support her argument. And this report gathered a lot of attention, won an award, then she filed a petition, and finally in 2024 we have a judgment which said no, this is not allowed. Caste-based discrimination is against, for example, Article 14, 15, 17, 21 of the Constitution. So this is the whole setup. And what she claimed in her petition was 3 types of discrimination. Let's see what were they. First is that she claimed there was manual labor के respect में. Manual labor, basically जब भी the prisoners are kept in a premises together, they do all the work on their own, from cleaning toilets to cooking. They do all the work. Now what was happening was कि lower caste people were given degrading tasks, while the higher caste people were given respectable jobs like cooking या फिर gardening. So ये चीज़ गड़बड़ हो रही थी, right? सो ये उन्होंने हाईलाइट किया. फिर उन्होंने बात की बैरिक्स की, मतलब जहाँ पे बैरिक्स इज़ द प्लेस वेयर हाउसिंग ऑफ द प्रिजनर्स इज़ डन. सो इफ़ देर इज़ दिस मच एरिया अलॉटेड फॉर हाउसिंग, सो एरियाज वर डिसाइडेड अकॉर्डिंग टू द कास्ट. इफ़ A caste people are going to live over here, then no individual from caste B can be allotted this area. So this is wrong. So this is also discriminatory. It is like saying कि अगर हम society में रहते हैं तो certain area will be allotted to Brahmins and certain area to Kshatriyas. This is discriminatory, of course. So this was what was highlighted. Third, she talked about DNTs and habitual offenders. Habitual offenders means people who offenders basically who have been held previously by any competent court for an offence, and they are being held again for that offence, then they are habitual offenders. Every state has its own definition of who will amount to habitual offender. कुछ cut off बनाते हैं कि the previous offence has to be, for example, more than 3 years, right? Like that. And DNT is denotified tribes. Now denotified tribes is basically what used to happen was in the British era. There was an act called the Criminal Tribes Act. Criminal Tribes Act of 1871. In this Criminal Tribes Act, the Britishers notified some of the tribes and said the members of these tribes are born criminals. Imagine, criminals. So this was what was held about them, and this continued until our independence. And after independence in 1952, such an act was repealed, and therefore the tribes notified under this act became denotified tribes, right? So this is the concept, but still there was discrimination going on with respect to these people in the prison premises. In the defense of the union and the state government, what happened was union government presented the fact that since administration of a prison premises is a state subject, okay, now state subject kaise? Because it falls under list 2. As you know, list 2 subjects are exclusive jurisdiction of the state governments and state legislative assembly actually. So agar state wants, then they can make the changes. It is beyond the powers of the union government. And they said all we can do is issue an advisory if you ask us, or we can amend our model prison code. Yes, so model prison code is basically what the central government prescribes. Then each state, according to its own needs and infrastructure and resources, makes it adaptable to their surroundings, right? So the state government is saying that the central government is saying that we will amend this model code, and baki we don't know, we can't do anything about this because it is state subject. Now after hearing both the parties, this Supreme Court of India, which was a 3-judge bench of Justice J.B. Pardiwala, CGI-D.Y. Chandrachud and Justice Manoj Mishra, they held first of all that this discriminatory behavior is of course against the articles 14, 15, 17, 20 and 23. Then they highlighted the fact that such discriminatory behavior has of course reinforced the caste differences, which is prohibited under our constitution. Then the Supreme Court of India went ahead and directed the union government to change the model prison rules and file a compliance report within 3 months. बेसिकली जो मॉडल रूल्स हमने यहाँ पे डिस्कस किए ना, जो यूनियन गवर्नमेंट बनाती है, इसमें वो चेंजेस करे और इसका ये की चेंजेस कर दी हैं, इसकी एक रिपोर्ट बना के 3 महीने के अंदर ऑनरेबल सुप्रीम कोर्ट के सामने पेश करे. सेम फॉर द स्टेट गवर्नमेंट. स्टेट गवर्नमेंट शुड मेक चेंजेस. 13 states were party to this suit, so all of them must make changes and submit it with the honorable Supreme Court. फिर Supreme Court said that in that information register that you keep about the prisoners, why is there a state column? Why is there a caste column? Because the caste identity of a prisoner is irrelevant for the administration of the prison. Then why does this column exist? So they said delete this column. Okay. Then they took suo motu cognizance of any kind of discrimination. For example, if there is a discrimination going on against a person on the basis of gender or orientation or any other thing, the Supreme Court wants to look further deep into this matter and has ordered the registry to assign a date 3 months after this, which is agar this judgment is being passed on 3rd October, 3 months after this, please present this case, where if any kind of discrimination is happening on any basis, caste, creed, religion, race, gender, etc., we will look into this matter. Then on the first day of that second cognizance वाला जो इन्होंने मैटर लिया है, suo motu cognizance वाला, जो 3 महीने बाद लिस्ट होगा सुप्रीम कोर्ट के सामने फॉर हियरिंग, उसकी फर्स्ट डेट पे जो सेंट्रल गवर्नमेंट और जो स्टेट गवर्नमेंट है वो कंप्लायंस रिपोर्ट सबमिट करे. These were the things that were held by the Supreme Court. These were the facts and the arguments presented, and now we know what the case is and what issues it dealt with. You can answer all kinds of questions from this topic. Sukanya Shanta versus Union of India. Okay, bye bye. See you next time.